Your Honour, I was addressing you on issues of law that this court will require to determine in immediate judgment application. Your Honour, if I could just ask you to look at paragraph 117 of my second argument. Your Honour, you'll see at paragraph A, the way in which we say the issue of law arises, and it's whether or not Midtown's claimant was entitled to enter or to file the confession of judgment and obtain the confession of judgment in circumstances where the defendant had not defaulted terms on the proper construction of the term sheet. That, I think, is uncontroversial. Now, the term sheet is, of course, subject to New York law, and in order to determine that issue, this court would require factual evidence in relation to the factual matrix against which the term sheet must be construed, and expert evidence on New York law. So we would say you would require evidence of New York law to determine whether or not the term sheet has been complied with or not complied with, which we say is a necessary step in any determination that the judgment is final and conclusive. And if you are with me on that point, then we get to point B, that then of course the issue arises whether or not we were in default of the term sheet, and that plainly requires detailed factual evidence and evidence of New York law. So both those issues, we say, require evidence of law and of fact. Your Honour, if I could briefly deal with the stay application that the learned friend has made to you. The application for security, we of course resist any application for, we ask you to stay these proceedings subject to the judgment of the New York court, or until the New York court has given its judgment. And I've already made submissions on that in respect of my jurisdiction application. Those submissions apply equally to any enforcement of the immediate judgment application, if not more forcefully. One of the fundamental differences between this court and the New York court, and it comes out from the statement of the second statement of Stephen Meister, which we served over the weekend, is that the New York court has powers, express powers, to unwind any enforcement of a judgment that it enforces. This court doesn't have those sorts of powers. So if it allows a judgment to be executed, we're faced with a situation where the judgment is then subsequently found by the New York court to be null and void. It's a very embarrassing position, effectively, because the execution steps will have been taken as a result of an enforcement order given by this court, which then turns out to have, by definition, to be based on a null and void judgment. And those execution steps will be very difficult to undo. Whereas the New York court reserves to itself express powers to unwind any execution that is taken on the basis of a judgment that is subsequently vacated. So there is a difference in the fundamental rules and the procedures. But that notwithstanding, the resistance to the stay is mounted on the basis, effectively, that we have been delaying these proceedings, and also that we are dissipating assets. Both propositions in my submission are wholly without merit. The delay proposition has to be looked at in the light of what the claimant has done. On the claimant's case, it was entitled to file this judgment by confession on the 31st of March. It waited until the 18th of August, the 23rd of August, before doing so. Over 5 months. No reason given for why it waited that long, or what caused it to trigger the filing of the judgment, or otherwise. Likewise, having got that judgment, it waited another 2 months, from August to October, before taking any enforcement action. So that's 7 months that the claimant has hung about without really doing anything to obtain the judgment or seek to enforce it. Against that, it's complained about us that effectively we delayed by 49 days, 30 days after the appeal period, before filing our notice of motion. And that we then set what is said to be an unusually distant return date for the notice of motion. The return date was set as the 18th of January. Now, that was set when the motion was filed on November the 11th. In the United States, there are various holidays that come up at that period of time. There's Thanksgiving, there's Christmas, and these holidays make a difference to whether or not the court will hear a case. More to the point, the claimants themselves applied to advance the motion, the return date of the notice of motion, to the 6th of December. And that application was, the judge for whom that application came in New York declined to sign it. That is at bundle 2B, page 562, the judge's declination to sign. Yeah. Now, if the New York court judge himself is effectively saying, by declining to sign a notice to advance the motion, that the motion has been properly set down as being on the date it's set down for, it simply can't be complained of us that we set it at an unusually distant return date. That is something the New York court has agreed with, the return date that we set, despite the claimant attempting to advance that date. So, those are the issues that arise in respect of delay. So far as disruption or the steps we've taken in these proceedings are concerned, there can be no allegation as such of us deliberately delaying the outcome. The application to stay the immediate judgment application pending the jurisdiction application was a legitimate one. It was rejected by Your Honour, but nevertheless it was based on an authority of the English courts, and I don't think we could be faulted for having made that application as such. So that wasn't any exercise in seeking to delay the outcome of this matter. So the mantra of delay, which the claimant has been chanting, firstly, doesn't fit comfortably in its mouth when it's waited 7 months before taking any action to enforce what it says is an indefeasible, absolute right to enter judgment against us. Secondly, where there has been no delay whatsoever on our part, except possibly allowing the period of appeal to expire and waiting another 49 days before bringing our notice of motion. So 49 days against 7 months is the completing period of delay caused by the various parties. As far as dissipation of assets is concerned, Your Honour, the evidence given by Mr. Feinstone is based on an affirmation filed in New York of Mr. Avi Friedman, whom you will recall from the email exchanges that we were looking at yesterday, is a manager of the claimants, or I think of their agent, DK Lenders. And that evidence is demonstrably inaccurate. We have filed evidence in opposition to it. We've repeated that evidence in this court. And, Your Honour, I could only invite you to read those witness statements to get a feel for whether or not it is accurate or otherwise. But more to the point, there is no evidence of us having taken any steps whatsoever in this jurisdiction, or even in onshore Dubai, to dissipate assets. And The only evidence that could be relevant to Your Honour, as far as this court is concerned, is evidence of dissipation of assets out of the reach of the order of this court.
Yes.
Not in the BVI or anywhere else, but only within Dubai. And there is no evidence whatsoever of that. So the dissipation of assets point, we say, doesn't begin to get off the ground either. So we come back to the basic test as set out in solid body. We say we do have credible grounds for defence. We say there is no point to be made about delay, and there is no other reason for granting security whatsoever. So we would resist any order for security. More to the point, Your Honour, as Your Honour has himself pointed out, there are parallel proceedings going on in other jurisdictions, and the risk to us, particularly in the DIFC where we have no assets at all, of an order of security, which, as you have also pointed out, effectively preempts the enforcement, the execution of the enforcement judgment, is significant. And it's simply not mitigated by my learned friend undertaking to not seek posting of security in other jurisdictions, because that is a matter for those other jurisdictions. His undertaking to this court has no bearing on what the other jurisdictions will.
Well, it does have a bearing on what he could ask of the other jurisdictions. If the claimants give an undertaking, they will not, in other jurisdictions that they seek to enforce, ask for security, which taken with security post together would sum up the total indebtedness, and that would bind them from seeking greater security in those jurisdictions.
Your Honour, that would be an undertaking given to this court. It could only bind them in this court. So they would be in breach of. It wouldn't be able to.
Responsible lawyers. And am I really to imagine that they may breach the undertaking to this court by seeking security in larger amounts contrary to the undertaking?
Your Honour, there are 6 separate jurisdictions involved, 6 different firms of lawyers. The coordination amongst them is not necessarily as
yes, but the claims remain separate. If I have had an undertaking, but if an undertaking given on behalf of the defence is private defence, and anyone who participated in the breach of that undertaking will equally be in breach of the undertaking. And I can see no grounds for imagining that there will be any breach of the undertaking.
Your Honour.
We may be, we're in the realms of hypothesis, and I simply raise this with your opponent, and he said he'd be kind enough to inquire about it, and I have no idea what that's gone to.
Your Honour, precisely. Your Honour, most telling of all, of course, is that the stay application in New York was made as long ago as the 20th of January. There has been no application for security made by the claimants in New York. So, in circumstances where they're not prepared to go to the New York court to ask them to get us to post security in New York, which is the primary seat of the action for this. These.
Who knows where your assets are?
Your Honour, as I understand it, no application was made for security in the Cayman Islands either, but I may be wrong.
That's wrong. Yeah. In fact, the response to the application of security in Cayman Islands was, well, we should leave it to New York because otherwise one might have overlapping orders all over the place. So the response will be the same in every jurisdiction.
Your Honour, those are my submissions on the application for security and the resistance of the state. Your Honour, if I could just make some brief reply submissions to those made by my learned friend. Your Honour, if I could start with the Schnabel case. Rather than take Your Honour to it, can I just point out the paragraphs that I believe are relevant?
Yes.
Your Honour, yes, I think it's tab 34. 35, I believe.
Yes, I know.
And in particular, we will ask Your Honour to read paragraph 77.
Yes.
And paragraphs 134. Both of which we say make it plain that in that case it was being decided that because no application had been made to set aside the default judgment, that was what rendered it final and conclusive. What is being said in paragraph 77 is that the approach that has been adopted is that until the steps are taken to set the judgment aside, the judgment is enforceable and is a final and enforceable judgment. As soon as those steps are taken, it ceases being final and enforceable. And that's repeated to some extent in paragraph 134.
Yes.
Your Honour, another of my the claimant's authorities to which you weren't taken is at tab 37.
Yes.
And that is the case of Nintendo against Bung Enterprises. If I could ask you to mark up paragraph 10.
Yes.
And in particular the quotation, I apprehend that every judgment of a foreign court of competent jurisdiction is valid and may be the foundation of an action in our courts. It is subject to the contingency that, by adopting a certain course, the party against whom the judgment obtained might cause it to be vacated or set aside. But until that course has been pursued, the judgment remains in full force and capable of being sued upon. So we maintain that the putting of our money where our mouth is by making the motion in New York is sufficient to render that judgment no longer final and conclusive based on those authorities. Your Honour, there's a passage in Naraju and Shelbourne as well, which I believe you were taken to the case, but not to this particular passage. And the case is at tab 24, I believe. And that is the passage. That's the one, yes. And at paragraph 131, halfway through the paragraph, the learned judge says, the English court is concerned with whether the foreign judgment is final and conclusive on the merits of the country in which it was given. There is agreement that it was. That is the only question on which the foreign law experts can properly opine. It is for the English court to decide whether the ingredients of the English doctrine of res judicata are fulfilled by foreign judgment, which has that effect in the jurisdiction in which it was given. So we say that the issue of whether or not it's res judicata is a matter for the DIFC court to decide, applying the principles of DIFC law. Obviously, my learned friend says it's a matter for the New York law.
So you disagree with the approach taken by the judge in the
Well, my Lord, there appear to be conflicting authorities on the issue, and it isn't really clear which approach should be adopted. The issue of whether or not it's res judicata in New York is, as demonstrated by this passage, a matter that will...
Was this a recognition or a enforcement case?
This was...
Was this a judgment being used extensively, and therefore all questions of recognition, or was the judgment being enforced?
I believe it was judgment being used defensively.
Well, then there seems to me to be nothing exceptional with paragraph 131. If it's enforcement, court has to decide whether it is final and conclusive. And if it's defensive, the court has, by looking at the judgment in the context of the proceedings and deciding whether the English constituents of res judicata are made up.
Your Honour, yes. Your Honour, if I can turn to my learned friend's submissions on the constitutionality point. It was said very early on in his submissions that there is no defence on my case to my learned friend's clients presenting the confession of judgment in the New York court tomorrow. Of course, our case is not so straightforward. Our case is that the term sheet, not having been adhered to, has effectively been repudiated. Or that would be our case if it came to it. The repudiation of the term sheet would then result in the confessions of judgment that have been provided pursuant to that term sheet also falling away. So there would be no confessions of judgment left to file. That doesn't detract from the fact that the debt under the guarantee or the credit agreement remains, but it does impact on this court's approach to the judgment. My learned friend made a point about the decisions before this court in Fisco and Furman, Okimar and IGPL. And he was effectively saying that those decisions militate against my jurisdictional challenge. In my submission, they simply don't, because they have nothing to do, any of them, with the point that is being argued here. They are all to do with Article 235 of the Civil Procedure Code. We are not arguing any sort of conflict with Article 235. We are simply arguing that the legislation through which the DIFC derives its jurisdiction to enforce foreign judgments is contrary to Article 120 of the UAE Constitution. That doesn't engage Article 235 at all. The fact that Article 235 exists is simply illustrative of the Federation having legislated in this field. It isn't our case that there is any conflict between the DIFC legislation and Article 235.
Do you accept that if your argument holds good in this case, it must follow that the onshore courts do not have jurisdiction to enforce foreign judgment?
Well, Your Honour, it would appear to so follow, except that to the extent they are acting consistently and they are acting on the basis of Article 235, which is federal legislation, in enforcing those judgments, then there is an argument both ways. Now, my learned friend says that, of course, that application of Article 235 is only based on Dubai law. But that is a matter for the Dubai courts, not a matter for this court. And it doesn't in any case render, as he was seeming to suggest, Article 235 in any way unconstitutional.
But for Article 235 to be applicable in another court, would require local legislation within the area.
Your Honour, yes.
And accordingly, there must be Dubai law which applies after that article, the CFI, to gives the onshore courts jurisdiction to apply that article. The other way around, the article is to be the code is to be applicable. And your argument is correct. So far, the constitutionality of the DIFC is concerned. Then it would seem to follow that the onshore courts too would be acting under an authorization which is in conflict with Article 120.
Well, the authorization that they're acting under is the bylaw number 5, which I believe is in my learned friend's authorities bundle. And it's a very short law. If we could just have a look at it.
Bundle 1 or Bundle 2 of their authorities?
I think it's bundle 1, tab 16.
Yes.
The law effectively says Federal Law Number 11 of 1992 regarding civil procedures in the Dubai courts shall be implemented. And that is the thrust of it. So to the extent that that law is conflicting with Article 120 of the UAE Constitution, yes, we would say it is unconstitutional. But that is only limited to the one article of the Civil Procedure Code. If the Dubai courts are nevertheless, in enforcing foreign judgments, being guided by that article, treating only judgments in which there are reciprocal treaty arrangements as enforceable, there is nothing objectionable in that. And it is our case, as was set out in my preliminary scoping argument, that in general, the Dubai courts use Article 235 as a guide to see whether or not, the way they look at Article 235, which requires reciprocity, is there a treaty? If there isn't a treaty, how can we know that there is reciprocity? So the enforcement of judgments by courts is not necessarily unconstitutional.
I follow that, but nonetheless, there has been no confirmed by federal legislation on the offshore courts to enforce foreign judgments, whether in the limited circumstances of reciprocity, reciprocal agreements or not.
Your Honour, yes. Yes. Your Honour, that takes me really to my next point, because it's not really my next point, but it may be a convenient point at which to take it, which is that just because the consequences of the argument I'm making have far-reaching implications, that doesn't detract from the merit of the argument.
It can't be on that level. It can't be. It just simply means, I think, that the court will look with care and some scrutiny in a proposition that has some far-reaching consequences. But if it has those consequences, it has those consequences that that's it.
Precisely.
The problem with that. This is not the fact that it may have consequences. It's not a knockout blow at all as far as your argument is concerned.
Your Honour, I'm grateful for that indication. Your Honour, the other point taken by my learned friend in his response to my submissions on constitutionality is that by reference to Article 123 of the Constitution, and it may help Your Honour to have the entire Constitution, which is at Bundle 3, tab 27. Your Honour, if I could first, just on a tangential point, take you to Article 99.3. That's at page 624.
Yes.
Article 99 provides the Federal Supreme Court shall undertake deciding on the following matters. Paragraph 3, considers the constitutionality of laws, legislations and regulations in general, if it is so requested by any court of the country while hearing a relevant claim. The concerned court shall comply with the resolution of the Federal Supreme Court rendered in this respect. And then paragraph 4, interpret the provisions of the Constitution if it is to be requested by any federal authority or by the government of any emirate. Any such interpretation is binding on everyone. So those are the only provisions in the Constitution providing for a constitutional reference to the Supreme Court. We looked at the Union Supreme Court law yesterday, which effectively mirrors those provisions. If I can now take you to Article 123. My learned friend says that Article 123, which states that notwithstanding Article 120, Clause 1, which provides that the UAE has exclusive jurisdiction in the matters of foreign policy and international relations, he said that that's a guide to what is meant by the term foreign affairs in Article 121. We don't shy from that. We say, absolutely, it is a matter of international relations. The recognition of the sovereignty of State A by State B, which is what the recognition of a judgment is at its basic root, is a matter of interstate relations. It is a matter of international relations. How can it be but?
Oh, until it was all about
But to the extent that I need to rely on any authority beyond Cape Industries, there are also the remarks of Chief Justice Swan in the DNB case.
I agree. Certainly, but I'm just looking at things analytically and historically.
Well, Your Honour, yes, there is no guidance given in any of the texts or in the cases as to what prefaced the decision in Wesby and I believe it's Schisterholz, in which the doctrine was first enunciated. It appears to have just sort of sprung up out of the judicial mind.
I think that the IC says that the thinking was that if a party makes itself amenable to the jurisdiction of state A, and having done so, is on the end of a judgment issued by a court of state A, then he is under an obligation to comply with that judgment. Wherever, so long as the state clause, which an English court applies, are satisfied.
Your Honour, yes. Your
There was
Honour,
nothing in that reasoning.
no, but that is simply a restatement of the doctrine itself.
Yeah, but that was how the doctrine was understood. That was the reason, the logic.
Yes, but there is no explanation of why that replaced the previous reciprocity stroke comity regime that the English courts have been applying since 1700. So 1700 to 1870, the English courts recognised foreign judgments on the basis of reciprocity and comity.
I thought that from, well, certainly from the early 18th century. Dicey gives us a hint in the very first case where a foreign judgment was enforced in an English court. Now, I hope I may have got this wrong, because I'm going to use those to steer me back to the correct path. My impression of reading Dicey that from the outset, the justification for the enforcement of foreign judgment was on the basis of an obligation which was recognised as being enforced because the party in question made himself amenable to the jurisdiction of the state whose court issued judgment. And that remains the situation really until Cape Industries. Have I got that wrong?
Your Honour, it may just help to have a look at Dicey, which is at tab 20 of the Defendant's Authorities bundle.
Tab 20 of the defendants. Yes.
And if I could take you to page 666, paragraph 14007, the basis of enforcement and recognition. English courts have recognised and enforced foreign judgments from the 17th century onwards. And there is then a footnote. See Sack in Law, A Century of Progress, Holdsworth History of English Law. It was at one time supposed that the basis of this enforcement was to be found in the doctrine of comity. English judges believed that the law of nations required the courts of one country to assist those of another as they feared by foreign countries.
Thank you very much.
So there is nothing that indicates what caused the shift.
Yes. Well, it would be, I should take the time to have a look at Holdsworth and to have a look at Baron Harvey, Russell Smith, and Williamson Jess. But thank you. You're quite right. I have a misrecollection of that part of that. So in a sense, you've got comedy, then you've got personal obligation, and then you've got what's said in Cape Industries, which is this sort of generalised notion.
Well, Cape Industries explains personal obligation as having underlying it the generalised notion of comity. So it's effectively... it provides a conceptual underpinning to what was previously a bald doctrine. You were then taken to the Cabinet resolution at tab 17 of my authorities bundle. And the submission was made to you that I beg your pardon, tab 17 of the Claimants Authorities bundle. That again, the list of Ministry of Foreign Affairs powers was silent on judgments and judgment recognition. Nevertheless, whether it's expressly dealt with or silent, the fact is that there are many, many treaties on the recognition and enforcement of judgments. Those treaties fall squarely within the powers of the Ministry of Foreign Affairs. So, to that extent, it cannot be questioned that the Ministry of Foreign Affairs, when it's concluding such treaties, is acting as the Ministry of Foreign Affairs and exercising foreign affairs functions. It was then suggested to you that Article 235 of the Civil Procedure Code cannot be legislation dealing with foreign affairs. But it was simply said that this can't be right. And you were then taken to the argument based on the bylaw, and a culmination of that argument was that Article 235 is unconstitutional. It simply doesn't follow that Article 235 is unconstitutional. But simply because Article 235 appears in legislation described as a civil code does not mean that it is dealing only with civil and commercial matters. It is a matter of nomenclature, but that doesn't affect the substance of what the article is dealing with. If it is dealing with foreign affairs, it is dealing with foreign affairs. Much as the courts, when they recognise and enforce foreign judgments, are likewise, whether they're employing the doctrine of obligation or otherwise, engaging in matters of foreign affairs. The other point that was made was that if my submission is right, then doctrines such as forum non-convenience, Article 583 of the Judicial Authority Law, etc., all fall away, and they all have to be looked at as the conduct of foreign affairs. My submission, firstly, I go back to the point that if that is the consequence of my submission, then that isn't a reason for failing to give it effect. But secondly, it doesn't go that far, because my submission is confined to interstate matters. The doctrine of forum non-convenience is not a matter that operates on an interstate level. Your Honour, I can't recall exactly the nature of the speeches in the Spiliada right now, but I believe there's more to it than just comity. But in any case, comity is a widely used expression. It doesn't necessarily engage the courts in interstate matters in the strict sense that I am describing, whereas the recognition of the judgment of another sovereign state does. At this point, and I made a note of it, my learned friend said that this would not be a very good way to deal with your foreign relations. Now, whether that was a slip of the tongue, or whether he genuinely intended to use the word foreign relations at that juncture, we would say is quite telling, because it just flows naturally that these are issues of foreign relations. That is what foreign relations covers, matters that affect states in their relations with each other. So his submission that by not recognising and enforcing judgments on the basis of Article 120E, it wouldn't be a very good way of conducting foreign relations, is of course answering the question that we're posing. What do foreign relations cover? The recognition and enforcement of judgments. The further point that was taken against me was to do with the disapplication of...
Yes, this was the second alternative.
Yes. And my learned friend submitted that the list of matters in Article 120 is extensive and such as would interfere with the jurisdiction of the DIFC court if it was taken as a cast iron legislative provision. But that list of matters is not one particularly extensive. There are 19 matters there, and they're mostly limited to federal matters. So foreign affairs, defence and the federal armed forces, protection of the UAE security against internal or external threats, security, order and government affairs in the permanent capital city of the UAE, federal officers and federal judiciary affairs, federal finance, taxes, duties and dues, federal public loans, post, telegram, telephone and wireless services, paving, maintaining and improving such roads as the Supreme Council may deem main roads, and regulating the traffic movement on those roads, air control and issuing licenses to aircrafts and pilots, education, public health and medical services, cash and currency, measures, standards and weights, electricity services, the federal nationality and passports, residence and immigration, federal properties and matters and all matters relating thereto, census and statistics for federal purposes affairs, and federal mass communication. None of that list interferes with the powers of the DIFC court, except possibly foreign affairs in respect of this particular issue. Now, Article 121, in which civil and commercial laws are excluded from the Constitution in respect of financial free zones, begins with the words, without prejudice to the provisions of the preceding article. So Article 120 trumps Article 121. So any exclusion on Article 121 is without prejudice to the matters in Article 120. So it simply is not, it cannot be said to disapply Article 120. That is done by Article 123, if at all, which starts with notwithstanding Article 120, Clause 1, and then provides for individual emirates to conclude local or administrative treaties. But Article 121, which was relied upon as disapplying the foreign affairs power, is simply not to the point. Now, the final point that I really would stress, Your Honour, is that the issue is, we say, very arguably a matter of foreign affairs. And we say that issue will go before the Union Supreme Court at some stage. I appreciate that is an interim submission, but the Dubai courts, when they are faced with the execution of this judgment, if it ever comes to a judgment of this court in this matter, will almost certainly be asked by my clients to refer the matter to the Union Supreme Court. We say this court should just bite the metal and do it itself, before another court or another authority does so and is referring this court's laws to the Union Supreme Court when this court had the opportunity to do so for itself. The public relations aspect of another court making that reference will not be lost on anyone. And it is plainly a matter that is very sensitive in the current environment. Your Honours, I believe, recently handed down an order in the Auger and Daman case, and you'll be aware of the ruling of the Judicial Tribunal in that case. I'm told that just yesterday the Dubai Court of First Instance effectively held that the rulings of the DIFC court in the Maidan case are void and of no effect. So there is, currently there is a great tension between the UAE federal system of law, which is a civil law system, the Dubai system of law, which is a civil law system, and the DIFC court's system of law, which is claimed to be a common law system. But that expression, common law courts, does not find itself, it is not based on any legislation. There is no legislation that says that the DIFC courts are a common law court. They are a court of the UAE and a court sitting in the UAE, which is a civil law system. A few, Your Honour.
Well, you're hardly going to suggest that it's not a common law court.
Well, Your Honour, no, I'm not. I'm simply saying that what we need is a proper determination of the various statuses of these different systems of law and how they intermesh. And that can only be done by the Union Supreme Court. And to that extent, we say a reference in this case is not only sensible, but we would say inescapable. So, Your Honour, I'm not suggesting it isn't a common law court, whatever that might mean. Obviously, the judges are from common law jurisdictions, and the law that is applied is very much the common law. But nevertheless, it's based on a statutory underpinning. Your Honour, yes. But that has an ancient history and a pedigree that has evolved over time. So, Your Honour, those really are my submissions. Your Honour, there's one final point, which is that if Your Honour is reluctant to determine this matter without Court of Appeal guidance, there is a basis on which you can refer the matter to the Court of Appeal under the court law, which provides that you have the power to refer issues of the interpretation of DIFC laws and regulations to the Court of Appeal. We would say that the way that you could couch that in this particular case is whether or not the DIFC laws are permitted by the on a proper interpretation, are permitted by the UAE Constitution. And if you were minded to get the guidance of the Court of Appeal, there is a route to it without requiring a full-blown appeal. Your Honour, there was, I believe you asked me yesterday to provide to you the exact reference to the Union Supreme Court case that I referred to. If I could just take you to tab 2 of my bundle of authorities. Your Honour, it's at page 4. Your Honour, I beg your pardon, it's at tab 1. No, I'm sorry, page, tab 2, I beg your pardon, it's page 4 at the top of the page. It's the final sentence of that paragraph. However, it is sufficient that more than one opinion revolves around a constitutional text, in a way actuating its judgment as per the wish and purpose of who made the Constitution, to justify referring to the court for getting rid of the mystery of this field, in order to guarantee the unity of the application and stability of the Constitution.
Thank you.
Your Honour, I have one further authority from the Union Supreme Court, which I don't believe I've shown my learned friend. It doesn't really, it simply underscores the point that a petitioner can't directly go to the Union Supreme Court. And with your permission, I'll hand that up.
I'm going to reserve judgment. I'm still here, Mr. Montague-Smith. I think you can have that here. If we can't deal with it now, you can, 2 or 3 days, you could submit a short paragraph.
Thank you.
Where do I put this then?
Can I suggest it goes at the end of our bundle of authorities?
At the end of volume 2,
Your Honour, yes. And Your Honour, you'd asked for the front page of McLaughlin. Your Honour, I believe that's been inserted in your bundle.
Has it?
And you will see that Campbell McLaughlin is a barrister practicing domestic schools chambers. He's also an academic at the University of Wellington in New Zealand. If there's anything else I can help you.
Thank you very much.
As far as I understand the way in which this authority is being deployed, I don't think it's inconsistent with anything anyone's saying. I think the point is simply that the defendant can't approach the Union Supreme Court direct, and that's not in dispute. Your Honour had 2 queries for me in the course of my submissions. I have a few other points in response, but I'll answer those first if I may. The first was in relation to the question of final and inclusive, and Your Honour had seen somewhere that it had found its way into an act, and was it on the merits or not? It was in fact... That's not the purpose of my submission, but simply to clarify that it was the words final and conclusive that got into the 1933 Act, and that there was a passage in Dicey which makes that point, and the point being that final and conclusive, that's very different to final. But there we have it. The second was in response to the undertaking that I was asked to inquire about. Emails have been sent, but we're dealing in New York, and they are 9 hours actually behind us, so they won't be waking up yet. It'll be about 6 o'clock in the morning now, I suppose. We'll make those inquiries and let the court know as fast as possible. I'll perhaps make some observations on that when I go through my learned friend's submissions. But I'm not going to take, I'll take as little time as I can, if I may. One point that was made in relation to the motions that are presently going on in New York, and reference was made to the section, or the Rule 317 application, which is the second lack of notice, quite. I can show that to you, Your Honour, if you like, but perhaps the better way is simply to give you the reference. And all I wanted to clarify was this, that my learned friend said in his submissions that a part of that application was the claim that the defendant should have had notice. But that's not part of the application at all. It's nowhere said that there was some obligation on my client to give notice under this process. What's said is that actually there is no obligation. It is an ex parte, and therefore it lacks due process. But the way it's put in New York is that you can apply the rules relating to setting aside default judgments to this particular type of judgment. And what the way it does that is it says, well, we see that what's required for a 317 is a motion, but you should effectively apply it anyway, by analogy. That's all that's there, full stop, no authority. So that's the basis of the application. There's no, as far as I'm aware, there's no authority in New York, there's certainly no authority in this court to suggest that that rule has any application in circumstances such as this, where there just wasn't a motion in the first place. Because the rule only applies where a motion was not served. So the only way they deal with that in New York is to say, well, it should apply by analogy, full stop. But it doesn't make any sense. If Your Honour's interested in that, I can give the reference very briefly as to how that case is put. It's 2B, page 569. As to the fraud defence, the position as I understand it is that fraud, as I would understand fraud, is not alleged in this court. That's what I understand. What's being said is that he doesn't need to allege fraud to establish fraud. It's a very difficult position.
What's being said is that what needs to be established is what is comprehended by the New York rule, which ends with the words or other misconduct. That is, as I understand, is what's being said.
That's in New York.
Yes, I know.
Yes, I'm sorry.
I'm going to clearly, I'm going to give very close attention to this transcript of the argument. But I think what was the other well, the approach is being taken approximates to the New York rule. That if you don't have to show Derry and Peak fraud, you have to show that the court was misled without there necessarily having been a dishonest intention
Yes.
accompanying it. But that's his submission.
Yes.
And the question then is whether the authorities you've referred to bears that out.
Yes.
And that would be for me to decide when I look at them.
Yes. I would simply direct Your Honour to the Dicey passage, which states the test as deliberately misled. That comes from a case which examines this question of what evidence one can use to show fraud. And so what the court was trying to justify was the difference between the rules when dealing with a domestic judgment and the rules when dealing with a foreign judgment. So if you have a domestic judgment, to show fraud you have to show that you couldn't have produced that evidence previously. With a foreign judgment, as under current English law, you don't. You do with arbitration awards because those are developed on a slightly different strand. So when addressing that, and this is all dealt with in Dicey, when addressing that, the court explained why it was open to a defendant to produce the evidence, fresh evidence, which could have been produced in the foreign court. And the question was whether or not they distinguished between the merits of the case on the one hand and the issue of whether or not the foreign court had been deliberately misled. And so it's in that context that the authorities say those words. And the authority, certainly, 14, paragraph 138 to 14139, they appear on page 728 of Dicey. And the authorities my own friend referred to did talk about deceived, but implicit in that is deceived is a qualitative statement. It's not simply misled in a neutral way, which itself misled can have several meanings, but deceived does not. Deceived is fraud. And then he took you to another authority, which was embedded in the case of Patel and Ali, and that was in that authority. The test was stated as being misleads and deceives. And my learned friend said misleads. Yes.
The court relied on a dictum from an earlier.
Yes, that was the one.
Which talked about malafide.
Right. So malafide could be sufficient then. Yes.
Make sure that I'm not.
Tab 13, I think it is in my learned friend. Defendants, I think.
That was it was the second authority.
Yes, that's right. Patel. Case.
And
The Jet Holdings and Patel. Sorry, yes, that's right. And so I was looking at the paragraph 347. So 347A. Yes. So the fraud necessary to destroy a prima facie case for stop by risk includes every variety of malafide and malpractice whereby one of the parties misleads and deceives.
There's a malafide of the equivalent element.
Yes, but they have by doing that to be misleading and deceiving. So misleading and deceiving is a necessary component.
Yes, but what that does is give colour to the notion of misleading and deceiving. But deceiving is involves.
Yes.
Yeah, this is malafide.
Yes. Your Honour, as to the question of the term sheet, again, we won't go back to it, but I noted my learned friend's position. He doesn't argue for an implied term of the term sheet.
No, that's what he said.
Doesn't. So that, in my view.
What basis of absurdity?
Well, but where does absurdity take one? Construction? Construction of what? Construction of a term, not of a contract. One has to construe terms and either imply them or not. So his argument of absurdity must be aimed at the absurdity that he says exists in the clause which requires that we forbear from enforcing until the 31st of March 2016. But where does that take the interpretation of those words? The words are, we shall forbear until X date. The literal meaning of that is after that date, we shall forbear. And Your Honour has absolutely in mind the point, which is the sort of damnatory is they're at our mercy. And the point is that before all of these arrangements, they were at our mercy already, in a different way, but under the guarantee. We didn't have the confession. So we did improve our position. There's certainly we get something out of it. But they were at our mercy in terms of enforcement, in terms of insolvency before. There's a period of abatement. Why is it absurd that they should be at our mercy after if we don't do what everyone hopes we will do, which is to reach a proper and full settlement? So there's nothing absurd about it, I would submit. As to stay, Your Honour, it was suggested that this court might not have a power to unwind its own orders in the event that the New York judgment goes against my client.
This court will wind you up since you're a company.
Unwind the order, sorry, I meant.
What orders are this court likely to make in the execution of the judgment if its order is being enforced?
So that's one thing. So I had understood my learned friend's submission to be aimed at the question of whether this court could reverse its own judgment, not execute on any obligation. That's a separate point, and I accept it.
I think he was suggesting that in New York there's an express power
Yes.
in the court to unwind the execution processes.
Yes.
And he says there's no such power in this court.
Yes.
Unwind the execution process. That begs the question, well, what execution processes are
Yes.
to be comprehended? Well, I think it would be unimaginable that this court would make the winding up of it. But when it's a Cayman Islands company, it would be for the Cayman Islands
Yes.
to make such a make. And the other array of execution processes that really are designed to lead to the production of processes.
Yes.
We know what range they are, charging orders,
Yes.
such as maybe the appointment of the receipt. And clearly, this court can compel a creditor who has received through successive execution on judgments that on the enforcement of has turned out to be vacated.
Yes. And I think that's the point that his submission was aimed at, because what he's saying is that there's a specific rule in the New York rules which provides for restitution in that event. So money to be passed back. No, well, quite. That's my point. That's my point. And there's authority for it in Dicey, which relates to the position where a default judgment is set aside after it's been enforced, and the result is simply that the judgment in England, the domesticated judgment, is also set aside. So it's in the common law, it's a feature of this. On the issue of security, very briefly, in response to my learned friend's submissions, my client is accused of delay. Firstly, in seeking the judgment, despite the fact that on his own case, his client's actually making certain payments all the way along. So there's no surprise that we're not enforcing while we're getting paid. And anyway, and there was some misstatement of the delay following obtaining judgment in New York, because the judgment was obtained on the 25th of August 2016, and then the claim form is served on the 4th or the 5th of October. So it's a month. It's not that slow, frankly, to obtain advice, get a claim off the ground in the IFC in a totally foreign jurisdiction to my client and moving forward. But anyway, it's beside the point, because my learned friend's need in his case for a stay is based on the time it would take for the New York court to get to the end of the process. My client's delay, if any, in bringing these proceedings, but has no bearing whatsoever on the length of the need for a stay. It would only make it shorter, wouldn't make it longer. So it's his delay that matters and not my client's, even if there was any. So it's quite irrelevant. My learned friend says that the evidence of dissipation is inaccurate, and for the purposes of this application, there is some evidence of dissipation. It's countered by evidence on the other side. Rather than descend into some sort of factual dispute over that, what I did was rely on the undisputed facts. So the account that I gave you, Honour, of the conversion of the EGAL receivable in the BVI into previously pledged shares, and therefore taken off the table for enforcement, that is undisputed. All that is said is there's nothing wrong with it. It's what we do all the time. And my submission was on that, well, that just makes it worse, because it's going to keep happening. And as to this question of multiple security, I accept there shouldn't be multiple security put down in multiple jurisdictions, but one can see the strategy that's being deployed by the defendant in every jurisdiction. There have been two so far where this issue has arisen, and both the defendant has said, well, we shouldn't have to give security in multiple jurisdictions. If they were coming to the table saying, we'll put down security for the judgment sum in New York, then this would be a totally different conversation. But the avoiding that is simply a matter of the mechanics of the order. And it may be that the solution is in an undertaking, and I'm taking instructions on that and provide that to the court as fast as possible. But another way of doing it would simply be to make provision in the order that the parties can come back to this court in the event that any other court makes, or any other security is ordered. It's just another way of doing it. It's not a principled response to security. It's just something that needs to be thought about when setting out the mechanics of the security. I have very few short issues. There was some suggestion that I was differing from the judgment in Naraji on this question of which law one looks at when deciding what's final. I'm on all fours with Naraji. The point is that one looks at the law at the place to understand the effect of the judgment, and then sees how that maps to the law of res judicata. But it's irrelevant where the laws of res judicata are the same. So if the broad principles are the same, what matters is the statute in New York that says this is the same as a judgment of the New York judgment of the New York Court, Supreme Court. That's what matters. Now, on the issue of, so now we're moving on to constitutionality, and I'll deal with that very briefly. On this issue of comity and the role of Adams and Cape. So my learned friend's right, 17th century enforcement judgments comity. By 1848, at some stage during that process, it's all about obligations. And then in 1990 you have Adams and Cape, and what is said is that actually what is said in that case is, yes, it is all about obligations. It is all about obligations, but underlying that, there is some sense that comity is important. But
the court goes out of its way to say that it is an interstate.
Well, you have the point. My learned friend says Article 235 of the CPC is not civil and commercial. Even if that were an attractive submission, it's been decided. IGPL, the whole of the CPC, is civil and commercial, and that's why it's disapplied here. First instance in DNB, I took your honour to that case, specifically on the question of Article 235. It is civil and commercial and has been disapplied, so there's just no scope for that at first instance. There's a slightly troubling submission towards the end that this court should be taking cognizance of what's going on in the Judicial Committee.
Well, I thought that was
Well, the trouble.
to be a jury observation.
Well, it's worse than that, it seems to me, because that committee is there to deal with disputes of jurisdiction between the two courts. So it's irrelevant to these proceedings. And insofar as what my learned friend is saying as well, the DIFC court should be a bit careful because it might have its wings clipped in other ways. Then what I would say is that this is precisely the sort of circumstance, precisely the sort of factor the DIFC court should put out of its mind in exercising independent judgment in these cases. Precisely why an independent judiciary and an independent court has been established in the DIFC. It's absolutely not right to be concerned about what might else happen, even if there are people who consider that what's happening in the Judicial Committee is unsatisfactory.
Yeah.
So I'll leave that one there. Unless there are any other points that missed, or if there's anything that I can assist with, then those are my submissions. I'm grateful.
I should reserve my